Okay, so you sent over that My Broadband article, the one titled Warning to Companies About Work from Home in South Africa. Got me thinking.
Mm-hmm.
So for this deep dive, let's really get into it, unpack the legal side for South African companies, thinking about, calling everyone back to the office.
Yeah, it's definitely a hot topic. The article hits on a clear trend we're seeing, right? Big sectors like telecoms, banking, financial services, even some government departments are moving away from full-on remote work.
It really seems like it. And it's not just here, is it? The article mentions this is happening globally, too.
That's right, it mirrors a wider shift.
But what struck me were those everyday signs here in South Africa they mentioned. The traffic getting heavier again. Oh, yeah. Longer commutes, paying more for petrol. Feels like we're shifting back towards how things were before the pandemic, doesn't it?
Definitely. Those are the real-world effects, aren't they? More people physically going into work. And, well, that brings us right to the core question the article tackles, and I bet it's on a lot of listeners' minds, too. Can your boss in South Africa legally tell you, right, back to the office?
Exactly, and to help figure that out, the article leans on Yvonne Makeffa. She's a director in employment law at Cliff Decker Hofmeyr.
A respected voice in this area, for sure.
And one of the first things she points out, which I found interesting, is that remote work wasn't exactly invented during COVID,
Yeah.
It existed before.
Right.
The pandemic just massively ramped it up.
That's a really important piece of context. It wasn't new, but the scale, the necessity during the pandemic, that changed the game.
For sure.
Now, looking at the legal side in SA, Makeffa points out, and the article highlights this, that our main labor laws, the Basic Conditions of Employment Act, the BCEA, and the Labor Relations Act, the LRA, they don't actually have specific rules laid out for remote work.
Okay, so if the main laws don't spell it out, then what governs this? How do companies and employees figure out where they stand?
Well, according to Makeffa's analysis in the piece, it really boils down to the individual employment contract.
The contract.
Yeah. That document is basically the rule book for these remote or hybrid setups in South Africa. What's written in your contract is, well, pretty crucial.
And she talks about this general idea, right? That employers can generally make changes to the workplace.
They can, yeah.
And this feels like but it has to be done lawfully and fairly.
Exactly. That's the critical qualifier. Lawfully and fairly.
So what does that actually mean?
Well, it links into something the BCEA actually requires employers to do. The written details of your job have to state your designated place of work.
Okay, designated place of work.
And this is where things get potentially tricky. There's a key difference depending on what that contract says.
Right. Let's break that down. What if my contract specifically says my place of work is remote? Like, it's written right there.
Okay, so if your contract explicitly states remote as your designated place of work, then your employer just ordering you back to the office without you agreeing to it. Well, Makeffa suggests that's very likely a breach of your contract.
A breach. Okay.
Yeah, potentially even a unilateral change to your terms of employment, which employers generally can't just impose. They'd likely need your consent.
That makes sense. A deal's a deal.
Yeah.
But what if the contract is more vague? Or what if it have a clause saying the employer can decide or change the place of work?
Right, that's the other scenario. If the contract gives the employer that kind of discretion, the right to determine or change the work location, then, according to the article's take on Makeffa's view, an instruction to return might be lawful.
Might be.
Might be. But, and this is still super important, it still has to be implemented fairly. That fairness requirement doesn't just disappear.
Okay. And fairly. What does that look like in practice? Does the article give examples?
It does. Makeffa emphasizes that fairness means employers can't, for instance, decide who comes back based on discriminatory reasons.
Like what?
Well, like race or playing favorites or, any other kind of unfair motive. It can't be arbitrary or discriminatory. The decision needs a solid business reason behind it and should be applied consistently.
Got it. Now, you mentioned the Labor Relations Act, the LRA, earlier. Even though it doesn't directly mention place of work, the article says it's still relevant. How?
Yeah, this is quite interesting. Makeffa's point, as presented, is that the LRA sort of infuses the whole employment relationship with ideas of equity and fairness. So even if your contract gives the employer some leeway on location, the LRA often means they still need to engage with employees.
You gauge how?
Through consultation, maybe even negotiation, especially when they're planning significant changes to working conditions like this. They generally need to talk to the employees or their representatives, like a union if there is one.
So even if my contract doesn't explicitly promise remote work forever, My employer probably can't just send out a memo saying, everyone back Monday, no discussion.
That seems to be the strong implication, yes. Failing to consult or not following a fair process, that could lead to legal trouble for the employer under the LRA, based on McKefa's analysis. It's about the process as well as the contract.
Okay. The article also brings up this other angle. What if working from home wasn't strictly in the contract, but it sort of became the norm, like a workplace benefit? Does that change things?
That's another layer, yeah. And even in that situation where it's more like an established practice or benefit rather than a hard contractual right, McKefa's view, according to the piece, is that consultation is still generally expected before an employer changes or removes that benefit.
So communication and fairness seem to be the running themes here.
Absolutely. Open dialogue, fair procedures, these seem key regardless of the exact contractual situation.
Okay, so let's try and boil this down for everyone listening. What's the main takeaway from the My Broadband article, based on McKefa's insights about returning to the office in South Africa?
I think the core message is, yes, South African employers can potentially require employees back in the office. It's not impossible. Okay.
But whether it's legally sound really hangs on two main things. First, what exactly does your employment contract say about your place of work? That wording is critical.
Right, check the contract.
And second, how fair is the process the employer uses to make that decision and implement it? If your contract clearly says remote, then yeah, getting your agreement, maybe negotiating, is almost certainly necessary.
So for anyone listening who might be facing this, the first practical step is dig out that employment contract.
Definitely. Read that clause about your place of work very carefully. Understand what you actually signed up for. It could really matter.
Yeah, absolutely.
And, this whole discussion, looking at these trends in South Africa that the article points out, it does raise a bigger question, doesn't it?
How so?
Well, thinking ahead, with work evolving like this, how should employment contracts maybe change in the future? To give both sides, employers and employees, more clarity, perhaps more flexibility around remote work, it's something worth mulling over, I think, as the future of work keeps shifting.